It's a privilege to join you and to be part of this wonderful conference. My name is Gideon Amissah, the Chief Executive of the Institute of Chartered Economists, Ghana. And it's a privilege to partner with this consultancy to bring this wonderful conference. I have to say kudos to the organizers of the occasion, Dr. Bohini and then Ms. Florence. You've done a good job. And I think that the organizers, those behind the scenes, kudos to all of you. Kudos to the speakers for their sacrifices to make this a wonderful conference. God bless all of you. My topic for today is to talk about bridging the gap between the employer and employee. And I think that the topic is very, very relevant to the current situation we find ourselves, where international labor organizations and United Nations and World Health Organization, they are all reporting on job losses as a result of COVID-19. And it's brought about a lot of disputes between employers and employee. And that is why I feel that the topic is very, very relevant to all of us. I have identified some few gaps that I think that interest you to note or to discuss with you. The first one has to do with the terms of employment, and then the rights and obligations of the employer and an employee. That area is very interesting, that you would want to know your right as an employer or an employee. Your right is an obligation of the other, the same way obligation is the right of another person. The third gap I identified has to do with termination of employment or discharge of employment, where after some time that you've come together as employer and employee, like marriage couples, you have to go your way, separate. How do you go away? How do you separate? We would discuss the ramifications of that separation or termination of employment. The fourth has to do with the remedies of employment. What are the remedies where there's wrongful dismissal or separation did not go well or termination did not go so well with either of the parties? What do they do? Where do they go? Those are the remedies. The forums with which they can address these issues are the fifth gap I identified. That is the forums with which you can address some of these labor issues. Where do you go? So we're going to look at these 5 areas, thematic areas. My approach is not going to be very academic, so you are not going to see me doing some empirical literature review or theoretical literature review or methodological review or some definitions and quoting some writers. No, I'm going to be very practical. Probably because of my background as a law student and then as an economic expert. So that is why I may take this approach. And you may also find me being very motivational, speaking to you about the vision that you have to get in life and be courageous, persistent, determinations. I feel those values are very good values, and but I'm not going to take that approach today. In the same way, I'm very sure that most of the speakers who had earlier spoken might have touched on the areas I don't want to venture into for now. So let's zoom into action. The first point has to do with the terms of employment or employment contract. Why do you have to know the terms? It's very, very important to know your terms. And these things, you can find them in the conditions of service that when you get a job, they give to you, or you can find them in your offer letter or some administrative manuals. At the same time, you can also find them in legal instruments like your constitution, bills of rights, and some labor legislative instrument that you may have. They all point you to know the terms of the contract. Again, you must also know the sector which you are operating in. Are you operating from the private sector or are you operating from the public sector? The rules sometimes changes based on the sector with which you are operating from. Also, you must have to identify the industry you are operating from. Are you operating from the banking sector, the insurance, the health, hospitality, manufacturing, oil and gas? The rationale is that it helps you identify with the various groups and unions as well as associations that are there. If you are an employer, you might have to identify yourself with employers association within the sector or internationally or nationally. If you are a worker or an employee, you have to identify yourself with the union, workers' union. They help in bargaining. The rationale is that they help you to bargain when you have to get some provisions across to the other parties. It's very important to know the terms of your contract. A crucial point with terms of contract is that there's something we call restraint of trade or restrictive clauses. These clauses, when you find them in your employment letter or conditions of service, either as an employer or employee, restricts the employee from taking up other jobs after he or she leaves the organization. Or sometimes they restrict you for not working, or you bind yourself for about 2 or 3 years before you can seek for employment. So that's why you have to pay attention to the terms of your employment contract. I believe that is a gap that everyone should know, either you are an employer or employee, so that we can bridge that gap. The second point, which I think is very, very interesting, has to do with the rights and obligations of the employer or the employee. As I stated earlier on, the rights of one party is the obligation of the other party. So the right of the employee is the obligations of the employer. Sources with which you can get some of these rights and obligations has to do with the International Labour Conventions. You can also look for domestic acts like the Labour Act or Workmen's Compensations. At the same time, you can also look at it from the human rights bills or some constitutions that you have with your country. I'm very sure that we are not from the same jurisdiction and people are from other jurisdictions, but these things are universal, or you can find them among the common law countries. The right of the employer, which is the duties of the employees. The first right of the employer is that the employer has a right to discipline you or a discipline employee. Every employer has that right to discipline, to impose sanction, interdiction, or dismissal. I'm sure that employees will not be happy to hear these rights of the employer, but that is the general convention that we have to deal with or come to terms with. The employer also has a right to strategic management, so finance, human resource operations, and marketing, various departments. It is the right of the employer to put in place these strategic management for these areas I've mentioned already. Internal controls, quality management, internal policies, costings, they are all the rights of the employer. The employee cannot take these rights from the employer. The crucial area which I'm sure employees will be very happy are the rights of the employees. Every employee has a right to remuneration, pay, salary. Once you work, you have to be paid. Right for overtime payment, hours of work has to be determined by either a legislative instrument or a law, or your offer letter will determine the number of hours that you have to work. If you go beyond that, you are entitled to overtime payment or allowance. Pensions contributions are your right as an employee. It is also the duty and obligation of the employer not to discriminate against. So every employee has a right not to be discriminated against, either because you are red or you are blue or you are from this country or you are a female or you are a male or you are whatever religion. Because of that, that should not be a factor. So that is a right of the employee. Annual leave and maternity leave are also crucial. Every employee has a right to some number of days to leave within the year, and that is the right of the employee. For women, and maternity leave is very crucial, that women should be allowed to go on maternity leave, and these are conventional principles from International Labour Organization to domestic laws. Persons with disability, are spoken about discrimination, should also not be discriminated against by mere fact that they are disabled. They should not be discriminated against, and that's the right. A crucial common law obligations of employers are the employer's liability. These are three issues that I have to mention, or three elements that you must have to do. Every employer owes the employee a duty of care to effective and efficient system. So it is the duty of the employer to put in place systems, effective ones, that work within the organization. That is the right of the employee. Reasonable people or employees are also to be employed. So you don't, as an employer, employ some indolent people within the organization who would cause problem, or go about their duties anyhow, and that creates problem for the other employees. So if you're an employee, it is your right to ensure that your employer gets reasonable people to be with you and to work with you. The human resource that will be provided must be reasonable, not people who come and cause problems for you. Safe working environment is also a very crucial issue that every employer must know, which is his obligation. He owes the employees a duty of care to ensure that the environment or the working environment is safe. Hazardous work, work that can cause fatal cases or death, or disfiguring injuries, or permanent or partial incapacitation. These are duties that every employer must know, and these are general principles that cut across all common law countries, and you must know. A critical example has to do with COVID-19 coronavirus. It is the duty of every employer to ensure that the environment is safe. Not that because you have employed me, once I come, I will contract COVID-19. It is employer's liability if the employee contract COVID-19 as a result of the employer's negligence by not putting in place effective management system, reasonable working colleagues, and safe working environment. The next one has to do with vicarious liability. Vicarious liability has to do with an employee who negligently causes harm to another person within the course of his employment. So if you're an employer and you employ someone who, in the course of his work, negligently causes damage to another person, it is your liability. And these are general principles. So if you give a driver a car, ensure that the driver will not be negligent. Because if your employer and a driver go and cause damage to somebody's personality, somebody's property, it is your liability. And that is what we call vicarious liability. The third gap I identified, I've dealt with the rights and obligation. The third one has to do with the discharge of employment, that is termination of employment. I've had a lot of issues that comes my way where some people have been dismissed or have not been paid salaries, or their contract have been terminated wrongfully, and that's why I think that is a gap that we all have to deal with, as whether you are an employer or an employee. And I find myself sometimes as an employer because I'm the CEO of the company, and sometimes as an employee because I have to report to a certain level of authority. So I understand these principles quite well. The employee can terminate the employment contract either by unilaterally terminating the contract through resignation, or there could be a mutual agreement where the two of them can come together and say, I've worked with this organization for some time, I think that it is time for me to go. That is a mutual agreement between the two of you, and that's one means to discharge an employment contract. The next one has to do with unilaterally. The employee, because employment is not forced labor or slavery, you can resign from any organization, and I think that globally it's accepted. The rationale is there that nobody is a slave for another person, so you can resign. The issue has to do with notices when you have to resign. Most of the times you are required to give a certain number of days notices to resign, and if you don't do that, the employer has relief that he can seek from any judicial forum for not giving notices to your leaving or your resignation. That is why the other point I'm coming to make, I don't think is very, very important or very good for any employer to do. That is abandonment of post. Some employees, they can just leave the employment without giving any notice to the employer. That is also not good. Although it's a mean of resigning or termination the contract. That is also known as constructive termination. The employer can also mutually terminate a contract. That is, the employer can sit with the employee and say that from now onwards, I think that we are not getting money because of COVID-19, because of this, because we are not getting more sales. So I think that we can separate or go our own way. That is a mutual agreement. Or another way is a unilateral termination. This time, the employer has no right to discuss with you as the employee, say that okay, no, unilaterally he can also terminate the contract and ask you to go. That is not dismissal, that is termination. And the reason why the employer can also do that without reasons to you is that it is a mutual principle, because you can resign without giving justification. In the same way, the employer can also not dismiss, but terminate contract of employment without giving justification or reasons. And I said that is known as the principle of mutuality. The issue with that has to do with notices, where once you have to terminate the appointment, you have to give notices to the employee that maybe 1 month from now, I think we should go our separate way. There is a very crucial issue where the notices come, the period between when the information is given to the employee and when the employee gets to leave their job. That period may be 1 month or 2 months. There are a lot of issues. Conventionally, it is supposed to be that you people work together as an employer, as an employee. All entitlement that is due to each other should be given to each other. It should be a smooth transmission or termination. Dismissal is also another form of termination or discharging employment contract, and that is where a lot of issues come in. That is a form of termination, but in this case, without justification. Justification is very, very crucial. This time you have to give reasons why you are dismissing someone. If you want to dismiss someone, it's very crucial you give reasons for dismissal, unlike mutual agreement or unilateral termination. But when it comes to dismissal, there is a need for reasons or justification. Notice may not necessarily require, or sometimes notice is required, but normally notice is not required that you can be dismissed. That is known as summary dismissal, that outright dismissal. When you get yourself involved in a misconduct, you can be summarily dismissed. The issue with dismissal is that it should go through a due process, or internal disciplinary process. That is, there are two factors that should apply here. The first one has to do fair hearing and biases. Fair hearing has to do with that the employee must be given a fair hearing. He must be heard either through a query or through a committee sitting to hear his part. Those who are accusing him must be allowed for him to question them. It should be a process that has been established that they go through. Otherwise, there could be something we call judicial review, where the court can reverse a decision of an employer to dismiss an employee. And there shouldn't be biases, where the person who has been offended by the employee is the same person who is the chairman of the disciplinary committee or is a member of the disciplinary committee. In that case, there is some perception or perceived bias in that case, and these things can result into wrongful or unfair dismissal that can be reversed by a court of competent jurisdiction. Constructive dismissal is another way. In this case, that is inducement, where the employee is being induced by the employer to quit the job. He will not ask you to leave the job, but he will do certain things that would get you to yourself resign, by not greeting you, abusing you, assaulting you, not greeting you, making you feel so irrelevant at the workplace that you would just decide to leave by yourself. And that is called the constructive dismissal. It is being frowned upon internationally, and when it happens, the employee has a right to redress, to get some remedies for constructively dismissing the employee. The next point has to do with frustration. Frustration is the case where there is an intervening circumstance, something that none of them is nobody's fault, and then the work is no more. It can be the destruction of the company, a subject matter is destroyed, the company has been burnt down. When it happens, the employer has no obligation to still pay you. One crucial example, which I'm sure employees will not be happy about, is the COVID-19, where government decide to go for lockdown and they ask all of you to stay home, and where there is no money coming into the organization, it is nobody's fault. That is known as frustration in law. Frustration. Something has happened, illegality, and because of that, we cannot continue operating. When it happens, it is nobody's fault. And in that case, I propose that there should be a mutual discussion between the two parties to come to terms how best they can go forward. Death and then illegality, imprisonment of the employee can also frustrate the employment contract where the employer is free to go. The next important thing, or the fourth gap I identified, is the remedies. The remedies that you can seek when you have been wrongfully dismissed or there is unfair dismissal. But as an employee, you can go for compensations. You can get compensation. And the compensation has to do with economic loss, not how you feel. Because you are dismissed, you have been disgraced, you think that you've been ashamed and people are gossiping about you because we are. No, that is not what we're talking about. Because you've been dismissed, maybe wrongfully dismissed for about 3-4 months, you don't get a job to do, then it is the obligation of the employer to pay you when you seek proper redress from a proper forum. That is how the calculation is going to be done, but not to your emotions or feelings. But it is upon the employee that he takes reasonable steps to mitigate the loss. So when you are wrongfully dismissed, you don't sit home and wait that because so you wait for like 5 years and you want somebody to pay you for the 5 years. No, you have to go and search for a job. If you don't get it, then it becomes obligation of the employer. The fourth gap, which will bring us to the end of our discussion, has to do with the forums. The first forum is the court. You can speak to a lawyer or go to the court, and you agree with me that that's very expensive. The second one has to do with human rights organizations. You can speak to them. There are some that are NGOs, there are some that are established by government. Speak to them. They are there constitutionally to support you when you have an issue. Labor commissions and departments are also statutorily bound to support you when you have employment issue, either as an employer or as an employee. You can seek redress from them. You can also speak to labor experts. Some of us, those of us in Ghana, if you have issues, you can speak to some of us. We've been dealing with some of these issues all over, and we will gladly help you to get redress for wrongful dismissal or termination of appointment. In conclusion, we've talked about bridging the gap. I'm sure when it gets to question times, we can address a lot of the issues that you may have. We've spoken about terms of employment. We spoke about rights and obligations of the parties. We talked about termination of employment contract. We spoke about remedies. And then we spoke about the forums with which you can address some of these issues. Thank you so much. It's been so wonderful to be with you and discuss these wonderful issues with you. I'm hoping that next year we can meet, and this time it's not going to be virtual, it's going to be physical, that we can know each other very well and network, and then have fun and then going forward. I wish you all the best and have a wonderful conference.